Leading off our next session is Nicole Bearce from Lowenstein Sandler, New Jersey. Nicole handles high-stakes, complex commercial matters, including pharmaceutical and mass tort litigation, as well as other commercial litigation. Nicole received her law degree from Harvard University, which we're told is one of the top 5 law schools in the Boston area. Here to discuss the art of dealing with former and current employees in litigation, please welcome Nicole Bearce.
Good morning. Welcome back from the break. So, to the fact finder, whether you're in front of a judge or a jury, a corporation comes to court through its witnesses who speak on its behalf. When a company is sued, its present and often former employees may be named as co-defendants or play the role of key fact witnesses. Indeed, depending on the case, a former employee may be the client's most knowledgeable witness. And in a climate where many companies have gone through reductions in force, you may find yourself in the situation where you're dealing with some tricky issues presented by working with former employees in this context. While there are a number of ethical issues that may arise, I am going to highlight 3 principal ones in the time that we have together this morning. First, I'm going to discuss conflict of interest, which must be considered if joint representation is on the table, and it must be revisited throughout the course of the litigation or the proceeding. Moreover, it may be necessary to obtain informed written consent. Second, I'm going to discuss indemnification and advancement of expenses, focusing on when it is allowed and when it is not. Third, I'm going to talk about compensation of current or former employees as fact witnesses and whether it is permitted at all, and if so, how much. So, conflicts of interest. Can the same attorney represent the company and an individual employee? This analysis starts with RPC 1.7. I have the New Jersey rule highlighted up on the slide, but it follows the model rule, which is followed in many states. So RPC 1.7 prohibits joint representation if there is a concurrent conflict of interest. A concurrent conflict of interest exists if 1, the representation of one client will be directly adverse to the other, which is usually the clearer example, or 2, which is the muddier one, there is a significant risk that the representation of one of the clients will be materially limited by the lawyer's representation or responsibilities to the other client. So there's a significant risk that the representation of the client will be materially limited by the lawyer's responsibilities to the other client. Typically, the interests of an individual employee and the company will be aligned as long as the individual was acting within the scope of his or her responsibilities. That said, conflicts can often arise in other circumstances. So the potential conflict can arise where there are allegations of intentional misconduct, criminal allegations, or there are certain causes of action where certain courts, you need to know the jurisdiction that you're in, that have held that the doctrine of respondeat superior doesn't apply. For instance, there are some courts that have held that the same lawyer cannot represent a government employer as well as individual employees that are named in a 1983 civil rights action. Although there are other courts that have held that a per se blanket prohibition is too much, and you need to look at individual cases and consider whether there is a substantial identity of interest among the parties, meaning they have consistent defenses and there's no actual conflict or likely possibility of a conflict to allow joint representation to move forward. So in certain cases, and this isn't just in the government context, you might have an employer that will agree that the employee was acting within the scope of his or her official responsibilities, and then that could take off the table the potential that there could be a conflict if something were to be alleged where the company could come back and seek reimbursement from the employee if they had acted outside of the scope of their responsibilities. Now, there are a number of reasons why a company might want the same counsel to represent both the individual employee and the company. That can include maintaining control over the defense and streamlining the cost of that defense, including the costs and expenditures and avoiding duplicative preparation and expenditures. It could be to contribute to the continuity of discovery and maintaining common access to the crucial facts that are at issue in the case by having everybody on the same team. It can also prevent some intra-company disputes and keep the employee, quote unquote, under the tent and promote a unified defense strategy. Now, it's possible that you could achieve these goals even if you don't have joint representation, but you have a good cooperative working relationship with a co-defendants counsel. But if you're considering joint representation, you need to weigh whether the benefits of that representation will outweigh the potential conflicts. Even if there is a potential conflict, counsel can still undertake the representation if each affected client provides informed consent, confirmed in writing, after full disclosure and consultation. So I'll say that again. Informed consent, confirmed in writing, after full disclosure and consultation. Now, while a public entity cannot consent to any such representation, at least under the model rule, it may differ in certain states because there are special concerns about the appearance of impropriety in the public sector. That is not the case in the private sector. In the private context, In the private context, you can have a consultation that includes an explanation of the common representation as well as the advantages and risks involved. Obviously, that's a tricky conversation. You don't necessarily want a key individual employee to be defensive from the outset when you have a conversation about a potential conflict. And I think it's important to start from the premise that typically the interests of both parties will be aligned. But you need to be candid and you need to be direct and matter of fact that if you think that something could come out down the road that the employee was working outside of the scope of their responsibilities, you want to be upfront about that because otherwise it can come back to haunt you. So I think the best course of action is to be direct, candid, and see if you can encourage the employee to give you some information about concerns that they might have about actions that they took that are under scrutiny. Number two, the lawyer must reasonably believe that he or she will be able to provide competent and diligent, hang on, I think I lost a slide. The lawyer must reasonably believe that he or she will be able to provide competent and diligent representation to each affected client. And then the third and the fourth factors. Let me just see if I can get myself back. Here it is. The third and fourth factors, which I think are apparent on their face, is that the representation cannot be prohibited by law, and the representation cannot involve the assertion of a claim by one client against another client in the same proceeding or tribunal. Now, informed consent, as its name suggests, can be given only after the lawyer communicates adequate information about the material risks and the reasonably available alternatives. Not surprisingly, whether informed consent is achieved, it's fact-specific, and it is the attorney who will bear the burden of showing that informed consent has been met if it is challenged down the road. Now, in some cases, there have been specific disclaimers included in the informed written consent. That doesn't necessarily negate the court's scrutiny of the specific facts in a particular situation, but it is one indicator that the court will consider as to whether or not informed consent was given. I've included an example here from the Rite Aid securities litigation, which was a class action that was asserted against the corporation, the CEO, as well as others. A partial settlement was reached that did not include the CEO, and during the course of discovery, there had been some questionable conduct on the part of the CEO that came out. He moved to disqualify the firm that had previously represented all of the defendants. The court found that the disqualification was not required and that the CEO had consented to the situation that had actually unfolded and needed to obtain new counsel. The disclaimer that had been included there, I have the language up here. It says, at the present time, we do not see any conflict that would prevent the firm from representing both the corporation and the employee. It is possible, however, that such a conflict may arise or become apparent in the future, in which case it is understood that the employee would retain separate counsel and that the firm would continue to represent the corporation. Now, there were other factors that were going on in the case, including the fact that the CEO waited about 9 months before he challenged the continued representation of the company by the former counsel, but it was one of the factors that the court took into account. The second bullet that I have at the bottom of the slide gives a court that came out the other way, and that's the Touchcom case, and that was in Virginia. In that case, it was a different circumstance, but you had a patent infringement case that Touchcom had filed against another company. In the context of that patent infringement case, its patent agent was deposed. Although the patent agent worked for a different company, it was an agent of Touchcom. Touchcom's counsel represented that patent agent for purposes of his deposition, prepared him for his deposition. That case was actually dismissed, summary judgment was found, and the patent was ruled to be invalid. Touchcom turned around and filed a malpractice case against the IP firm as well as its patent agent, but was still continuing to represent Touchcom. The patent agent challenged the continued representation by that firm and held that he had disclosed confidential information when the same counsel had prepared him for his deposition in the initial patent infringement case. And there had been a disclaimer about a potential conflict in the patent infringement case, but the court found that that wasn't enough to save the situation there because there had been a disclosure of confidential information and it upheld the disqualification of the law firm. So you need to keep three things in mind when you're dealing with potential conflicts of interest. There needs to be adequate disclosure up front. You should obtain written informed consent, and you need to revisit the analysis throughout the course of the pendency of the litigation to see if the circumstances have changed. The second topic that I want to address is indemnification or advancement of expenses. Can the company pay for its employees' legal expenses? Now, all states have statutes authorizing indemnification under certain circumstances. I have Delaware's highlighted up here. It's comparable to many statutes that are followed in other states. In Delaware, if the person acted in good faith and in a manner the person reasonably believed to be in or at least not opposed to the best interest of the corporation, and with respect to a criminal action or proceeding had no reasonable cause to believe the person's conduct was unlawful, then indemnification is proper. In other words, the employee may be reimbursed for losses incurred as a result of the employee's proper exercise of his or her official responsibility. In fact, it's been recognized in case law that indemnification may be mandatory if an officer or director is successful in litigation on the merits, which includes settlement for dismissal with prejudice. In your materials, I've included the New Jersey statute because we often deal with that, but it's comparable to the Delaware statute and includes similar language. Now, advancement of expenses may be different in that it involves payment of expenses either as they are incurred or may be advanced before a proceeding is concluded. Many state statutes require that an employee provide an undertaking to the employer that requires repayment if it is determined that the employee would not have been entitled to indemnification in the first place. So you need to keep that in mind and understand what the governing statute is depending on which jurisdiction you are in. You also want to keep in mind that rights of indemnification and advancement of fees can often be addressed and modified in a company's certificate of incorporation or bylaws, but those cannot run counter to applicable statutes. So you'll want to be aware of the governing jurisdiction and what is prohibited. For instance, in Delaware, and I've got this highlighted on the slide, it's clear that an employee cannot be indemnified if found to have violated the duty to act in good faith. Another example, this one from New Jersey, an employee cannot be indemnified where he or she has breached the duty of loyalty, where he or she did not act in good faith or knowingly violated the law, or if he or she received an improper personal benefit. Let's talk for a minute about payment of legal fees where it's determined that joint representation is not the best course of action. Companies may look to a friendly attorney or firm to represent individual employees, but still pay that other counsel. That raises a potential problem under RPC 1.8F, which prohibits an attorney from accepting payment from a third party other than the client unless, you'll see a theme here, 1, the client gives informed consent, 2, there is no interference with the lawyer's independence of professional judgment or with the lawyer-client relationship, and 3, information relating to representation of the client remains protected as required by RPC 1.6. And 1.6 is the rule that governs confidentiality. The New Jersey Supreme Court examined the interplay of these various RPCs in a scenario where the state had filed a grand jury investigation against a company and they named 3 specific individual targeted employees. The company brought in 4 different law firms They brought in one law firm to represent each of the individual employees, and then brought in a fourth law firm to represent the non-target former or current employees. And the court analyzed whether or not that was appropriate. The court ultimately found that it was, but found that confidentiality needed to be maintained, and there was a restriction on the information that could be provided to the company by the lawyers who were representing the employees. So the court laid out 6 different conditions that must be satisfied in that kind of a circumstance. So again, it starts out, number 1, informed consent of the client. Number 2, there can be no interference with the professional judgment of the lawyer. Number 3, there can be no current attorney-client relationship between the lawyer and the company who's paying the bills. Number 4, there can be no breach of the confidentiality of communications to the company. The company must process and make the payments promptly, and the court found that the company needed to be scrupulous in following through on that representation and couldn't just decide that it wanted to withdraw without, frankly, receiving court approval. I wanted to just highlight number 3, which required that there be no current attorney-client relationship between the lawyer and the company. If you're facing this kind of a situation, it is best to bring in law firms that you don't have a previous relationship with, so that, again, there's not this appearance of some kind of impropriety. Compensation for testimony. If you're dealing with current employees, you're really not going to deal with this specific question, because you're going to have the employee, yes, they're going to have to handle their day job, and they're also going to be involved with helping out with the litigation, and there may be some other issues involved with smoothing that over. But in terms of compensation, it would not be surprising for former employees to ask that the company give them some money for the time and the effort that they spend preparing and or testifying at a deposition or trial. You need to be careful. As a general matter, when a party to a litigation calls a witness because of that witness's personal knowledge, public policy dictates that such a witness may not be compensated for his services. Now, I'm citing a District of New Jersey case here, Goldstein versus Exxon, for that proposition. And in that case, it was an age discrimination case. The supervisor of the plaintiff had since retired from the company. The company brought the supervisor back in, entered into a consulting agreement with him so that they could pay him for the time that he spent helping them get ready for the case. The court found that it was improper and rejected Exxon's attempted argument that the supervisor was going to be providing lay opinion testimony under Rule of Evidence 701, which they argued was akin to an expert witness, and they're allowed to receive reasonable compensation. The court rejected that and found that it was still in the realm of a fact witness, notwithstanding that he might be giving lay opinion testimony. It still needed to be based on personal knowledge, so the court rejected that rationale. Compensation may not be permitted even if the amount of time committed is extreme. Now, this is an older case from the Seventh Circuit. I recognize it goes back a ways in time, but I think it still echoes, or it's still echoed in more recent cases like Goldstein. Here we had a retired former employee who met with counsel a number of times, spanned a number of years, helped develop a very detailed memorandum of historical knowledge. And the lawyer paid him for that time. The court found that it was inappropriate because of the potential, what they call dangerous consequences of this type of payment. And what courts are concerned about is the potential to affect, even unintentionally, the content and substance of a witness's testimony. You don't want to do it anyway. It raises the prospect of bias and the potential for a witness to perjure himself or herself to give more favorable testimony. Something else to keep in mind, and I realize I'm running short on time, there is a federal anti-gratuity statute which also prohibits anyone who directly or indirectly corruptly gives, offers, or promises anything of value to a person who is going to appear as a witness. I wanted to point out there's actually a typographical error on this slide. The site should be 201B3 in the first bullet and 201D. So please make that note in your materials. But the anti-gratuity statute recognizes that compensation can be provided for reasonable costs of travel and expenses incurred while appearing. And courts have recognized similar kinds of exceptions when, again, it's costs and expenses for attending or testifying a hearing. Authority is split, however, on whether payment for time in preparation for testimony may be reimbursed. Jurisdictions that follow Goldstein and its progeny have found that it's improper, that it's essentially akin to paying for testimony if you're paying a witness for the prep time. But there are other cases, a relatively recent case from the District of Kansas, that actually didn't find that those two things were analogous and found that compensation was okay. I would also point out that you want to be attentive to whether or not you're dealing with former employees to help you understand and put together your defense. But if you don't have an intention of calling them as a fact witness, you may be able to enter into a consulting agreement if you're very specific about the role that you're bringing them in to help you understand records or documents or information that may be integral to you understanding if there's no current employee that has the knowledge that you're looking for. The key is whether or not you plan to have them called in as a fact witness, and you might not know that at the very outset when you start working with that individual. So you want to keep in mind, and the two things you want to do is you want to be as specific as you can be in defining the role that you're compensating them for. If they're, for instance, analyzing a specific database, if they're looking at historical personnel records, if there's something that they're helping you interpret, be very specific in what you're paying them for. And number two, you want it to be a reasonable rate of compensation. If there's some contractor out there that you could bring in to give some kind of comparable service, but they don't have the historical knowledge that you need, see what rates they charge and use something like that as a benchmark. And then the final point that I wanted to make is, to the extent that you're memorializing this in a consulting agreement or in an informed written consent document like an engagement letter, stay away, be wary of anything that includes any connection with the witness's information being truthful, material, helpful. You don't want there to be any connection at all to connecting their information or potential testimony down the road with the actual merits of the case. Just don't do it. And I apologize for going over time, but thank you.